Lord.
Good questions, though, huh?
I appreciate it. I appreciate your tenacity. I'm sorry, Stephanie? Is that what? Princess. Oh, Princess. I'm sorry. Hi, I'm Kim. Nice to meet you. Oh, the people sitting in the front, I didn't recognize you.
Yeah, I do. I just got like 3 weeks ago.
Oh, nice. Who you work for? Oh, yeah, you were the first one here.
How you tell who's news? She's pauses.
Right. Well, nice to meet you. Welcome. Glad you're here.
Michigan must be quite different. That's what my friends who live there say. You should find it. So weird. Yeah. Where are you from?
Is there something in your system that I'm not seeing?
Yeah, there's a lot of
somewhere. Where'd you move it? Thanks. No. Just warming up the podium for her. We are going to be getting going here in just a couple of minutes. Good afternoon, everybody. Glad you all could make it on such short notice. I never doubted any of you. When we do have questions, I'm going to ask you to get your hands way up high. I'm going to be over here. I can see the whole room, front to back. Get your hands up high for me. I'll call you out. When I do so, even if I do say Ben Solis with Gongwer, please reiterate that back before you ask your question with the name and affiliate. Otherwise, yeah, I will see you all a true shortly.
Good afternoon, everyone. Joining me up here today, we have Chief of our Criminal Justice Bureau, Daniel Hageman Clark, Deputy Chief of our Criminal Investigations Division, Sam Miller, First Assistant Attorney General Danielle Rousseau-Bennett, and First Assistant Bill Ralston, and also Assistant Attorney General Kayla Caprino. And I'd like to thank all of you guys as well as some of our investigators on this matter, Bob Bernard and Brian Ferguson. Thank you so much for your hard work. In January 2022, Rebecca Chatfield, sister-in-law to former Michigan Speaker of the House Lee Chatfield, publicly reported that she was sexually assaulted by Chatfield over the course of many years. The Michigan State Police and special agents from the Department of Attorney General launched an investigation into her reported sexual abuse. That investigation was later broadened to include reports of financial crimes, including stealing and embezzling money from various tax-exempt political action committees, otherwise known as PACs, and one 501c4 affiliated with Chatfield's time as an elected official. The accounts under Lee's control took in over $5 million in just 6 years, and more than $2 million in the final year of Lee Chatfield's public service as Speaker of the House. To call him, as many have, a prodigious fundraiser would not be an exaggeration. And a great deal of the money raised and spent by Chatfield involved the 501c4 organized around July 2017, named the Peninsula Fund. The Peninsula Fund is a registered 501c4 nonprofit, quote, social welfare organization, the type that is commonly misused as political slush funds to accomplish the legal types of bribery Lansing has become accustomed to. There's not a lot you can't do with dollars in such an account, provided your record keepers, accountants, or law firms handling the funds are creative or clever enough for your taste. But however broadly defined, all the expenses made from these funds must be in the pursuit of advancing the goals of the organization, and it is a very low bar indeed. These types of nonprofits are different than the ones you may be familiar with or regular people donate to. They don't provide charitable funds to sick children or communities in need generally. They're most commonly political dark money dumping sites that can accept unlimited contributions from corporations and individuals without publicly disclosing any of their donors or paying any taxes. Their social welfare amounts to politicized speech and quote-unquote issue advocacy. The funds are popular because they make it easy to raise large sums of money, and there are very few rules on how it can be spent. To date, our investigation has uncovered evidence that Lee Chatfield used various different schemes to embezzle, steal, and convert both private and public monies to fund a lavish lifestyle that his state salary could not possibly afford. This included luxury shopping, fine dining, and extended vacations in swanky hotels and various exotic locations. It is not an exaggeration to say that his employees, friends, and family all benefited from the extravagant misspending of these funds. While the entirety of the investigation is not yet completed, my department is moving forward with 13 charges against Lee Chatfield following a years-long investigation by the Department of Attorney General using special agents, assistant attorneys general, and the Michigan State Police into rampant and flagrant misuse and misappropriation of political nonprofit funds while Lee Chatfield was Speaker of the House of Representatives. In addition, Stephanie Chatfield, wife of Lee Chatfield, has also been charged. I should remind everyone that charges are just that, charges, and that a person is presumed innocent until and unless proven guilty in a court of law. With that, the following charges have been filed in the 54B District Court in East Lansing against Lee Chatfield. Count 1, conducting a criminal enterprise based on 10 predicate offenses, a 20-year felony. It was determined during the course of the investigation that Chatfield employed a variety of separate financial schemes to line his own pockets. These schemes included using a 501c4 social welfare organization to pay off his personal charges on credit cards, utilizing a check kickback scheme from his PACs, improper mileage reimbursements from state monies for trips that were never taken, and a scheme to sublet an apartment that was paid for with 501c4 monies for Lee Chatfield's benefit. The first scheme relates to charged count 2, embezzlement from a nonprofit in an amount greater than $1,000 and less than $20,000, a 10-year felony. And count 3, conspiracy to commit embezzlement from a nonprofit in an amount greater than $1,000 and less than $20,000, a 10-year felony. These counts are against both Lee and Stephanie Chatfield. For counts 2 and 3, the Chatfields converted to their own use money from the Peninsula Fund, a 501c4 regulated account. From February 2020 through April 2021, Lee Chatfield made $132,000 in purchases on his personal Chase credit card. Peninsula Fund money was used to pay off the entire $132,000 balance for all 14 consecutive months. While we have uncovered no evidence to indicate that any of these expenses were proper or legal in nature, it is clear that numerous charges during this time frame were unquestionably personal and only personal. The Chatfield family went on vacation to Universal Studios in Orlando, Florida. Chatfield's credit card was used to make purchases at several souvenir shops, grocery and restaurant purchases, goods from wineries, party stores and restaurants, food delivery, and recurring bills from Apple.com. Transactions also include luxury purchases at UGG, Coach, and a surf shop in Florida. All charges during this time frame, again, were paid for using funds from the Peninsula Fund, a social welfare organization. Lee Chatfield and his wife, Stephanie Chatfield, worked together to facilitate using Peninsula Fund money to pay for Lee's personal credit card charges. While Lee Chatfield was the person whose Chase credit card was used, Stephanie Chatfield's role was to monitor the balance and make payments from the Peninsula Fund's accounts. The evidence shows that Stephanie Chatfield made payments to Lee Chatfield's personal credit card directly from Peninsula Fund accounts. The remaining counts apply only to Lee Chatfield. Counts 4 and 5 are charged as alternative theories. Lee Chatfield is charged with embezzlement from a nonprofit organization for $1,000 or more, but less than $20,000, which is a 10-year felony, or alternatively, larceny, $1,000 to $20,000, a 5-year felony. For count 4, a $5,000 check drawn on the Chatfield Majority Fund was made out to Aaron Chatfield, Lee Chatfield's brother. The check, dated November 2nd, 2020, was neither wages nor a bonus. Lee Chatfield gave the check to Aaron and told him he could keep $1,500 and Lee Chatfield would take $3,500 back. Lee Chatfield cashed the check on December 10th, 2020, in the lead up to the Chatfield family vacation in Orlando, Florida, and Universal Studios to offset the cost of the family trip. Similarly, for count 5, a $5,000 check drawn on the Chatfield Majority Fund was written to Wilbur Lovett, a friend of the Chatfield family. The check is dated December 12, 2018, and labeled as wages in the memo line. However, Lovett did not work for the Chatfield Majority Fund. Lee Chatfield, Rob Bernard, Aaron Chatfield, Paul Chatfield, another brother of Lee Chatfield, Robert Anderson, an employee of Chatfield, and Lovett all went to the Bahamas together from December 14th, 2018 to December 17th, 2018. The trip cost approximately $32,000 and was paid for by Rob Bernard and then reimbursed by the Peninsula Fund. While in the Bahamas, Lovett used $2,000 of the money from the check himself and gave the remaining $3,000 to Chatfield as requested. Counts 6 through 8 are embezzlement, $1,000 to $20,000, a 5-year felony, or in the alternative larceny, $1,000 to $20,000, also a 5-year felony. Similarly, in each of these charges, checks from the Chatfield Majority Fund 2 were provided to friends and family of Lee Chatfield, whom he then instructed to cash the checks and provide much of the cash to him for personal retail and bar expenses for trips he took to Las Vegas, Nevada in May 2018, the Bahamas in December 2018, and a family vacation to Universal Studios in Orlando, Florida, and contemporaneously with Lee Chatfield, Paul Chatfield, Aaron Chatfield, Bob Anderson, and Wilbur Lovett's November 2020 trip to Miami, Florida. Counts 9 through 11 are for embezzlement by a public officer over $50. Those are 10-year felonies. As a member of the Michigan House of Representatives, Chatfield was entitled to receive a travel reimbursement each week for one round trip between Lansing, Michigan, and his home district, Michigan's then 107th district, which totals 448 miles. Each month, Chatfield submitted paperwork showing which days he claimed to have traveled to and from the district. From January 2019 through December 2020, Lee Chatfield received over $30 in reimbursement for travel expenses on certain days. However, Chatfield's calendar, personal credit card, and Peninsula Fund spending indicate that many of these times he sought travel reimbursements, but a trip from Lansing to his home district was never made. Of the 42,337 miles Chatfield sought reimbursement for, approximately 21,280 miles appear to be associated with trips never actually taken, equating to $12,299.84 of taxpayer money that was improperly reimbursed. Records indicate that Lee signed reimbursement forms for days he was actually in Phoenix, Arizona, Puerto Rico, Detroit, and in one instance for mileage reimbursement for when he took a flight to Pellston instead of making the drive. Count 12, embezzlement from a nonprofit, $1,000 or more but less than $20,000. That's a 10-year felony. From December 2017 through December 2019, Lee Chatfield rented an apartment from Walnut Tree Properties, a company that was owned by the Michigan Automobile Dealers Association, a lobbying firm that is run by Terry Burns. From December 2017 through December 2019, Lee Chatfield's monthly rent of $775 was paid for by the Peninsula Fund. But at the same time, Lee Chatfield was subleasing one of the bedrooms in the apartment for $250 a month, and then he just pocketed the change and kept that instead of ever reimbursing the Peninsula Fund. Finally, count 13 is a Charitable Trust Act felony violation. This charge is an additional and separate theory of liability for Lee Chatfield's use of Peninsula Fund money to pay off the balances on his personal credit card. These funds were used for purposes other than that which the funds were contributed or solicited, which is a violation of the Charitable Trust Act. In service of this investigation, my team of investigators and prosecutors conducted dozens of witness interviews, obtained tens of thousands of financial records, extensively reviewed tens of thousands of digital documents, engaged a forensic accounting firm to review bank records. We conducted all this document review through a rigorous operation of a taint team, and of course along the way also charged two high-ranking Chatfield employees with significant felonies, those being Robert and Ann Menard. And of course this has been one of the most highly publicized public integrity investigations pursued by this department since I took office, and it's been a significant undertaking. But we're also announcing today that the investigation into the reported sexual assault by Rebecca Chatfield is closed without issuing charges. We've made that decision that we cannot reach the appropriate proofs required as it relates to the allegations of sexual assault, and we do not have the sufficient evidence under the relevant criminal statutes. Our investigation, though exhaustive, failed to produce evidence to meet proof beyond a reasonable doubt, the standard that must be met in order to bring charges. We commend Rebecca's strength, her bravery, and her courage in stepping forward to tell her story, and her disclosure led to our office's full investigation into allegations of other criminal activity. Were it not for her, we likely wouldn't be here today announcing charges at all. We are continuing our lengthy review of documents, and let me be clear, the investigation remains ongoing. We have definitely not ruled out additional charges against the Chatfields and many others, but we are confident in what we have alleged and charged today and felt as though it was important to at least begin the legal process. Complex financial investigations can take years to complete and to try in court. For instance, the prosecution of Eric Smith, former Macomb County prosecutor, took over 3.5 years from the date charges were announced to the date of Smith's sentencing. Likewise, the prosecution of Sharikia Hawkins, former Southfield city clerk, took over 3 years to conclude. We have current litigation involving the false slate of electors who were charged over 9 months ago, but they're still pending in district court. And similarly, the false signatures defendants that involved the Republican gubernatorial candidates were charged in June of 2023, and we don't expect a decision on bindover to take place until June 2024, a full year after being charged. And as you will recall, with the recent conviction of Rick Johnson, another former Michigan Speaker of the House, the U.S. Attorney's Office took a full 6 years to investigate before they brought charges at all. Public integrity matters, and holding elected officials who engage in corrupt acts and who abuse their authority to account has been a top priority for this office during my administration, but I am some approximate 2 years and 8 months away from leaving office. And the next Attorney General may not prioritize these cases as I have done. This case and the other major cases we've announced have all highlighted the many ways Michigan's current campaign finance and disclosure laws are inept and make concealing enormous amounts of fundraising and spending far too easy. We have a unique opportunity right now to truly impact change that will benefit Michigan and our residents for decades to come. I think it's fair to anticipate a concerted effort to delay these proceedings or to run out the clock until I'm no longer in office, as we've seen with some other cases. And this matter involves a significant amount of materials that will need to be reviewed by the defense attorneys involved in this prosecution. And those materials will need to be reviewed before a preliminary exam can be conducted, and that process needs to start as soon as possible, and we will be providing that discovery to defense counsel in short order. Additionally, the majority of financial crimes included in Michigan's compiled laws carry a 6-year statute of limitation. Lee Chatfield, I believe, first took office in January of 2015. Now, the clock is ticking on potential counts. Better to charge the crimes we are confident in and that we can prove now rather than wait months or years down the road to complete an investigation in its entirety and then lose the ability to charge altogether. So this is the beginning of the charging process for the former speaker, but no one should expect that that process has been concluded with the announcement of these particular charges. In regard to our current system, in which elected officials have come to rely upon dark money PACs for various expenses, there certainly are genuine out-of-pocket expenses that come along with holding public office. Constituent town halls and policy conferences are two examples that legislators today might be forced to pay out of pocket if not for these types of accounts. And from the 1970s through 1994, Michigan actually allowed for office expense accounts through the House Fiscal Agency to cover those costs that would be properly covered as legitimate office expenses by employers were they in the public sector. However, in 1994, in an ironic move to, quote, improve their public image, lawmakers eliminated these accounts. While these accounts could accept donations from many of the same funders who contribute today, the transactions of these accounts were then fully transparent and subject to the same contribution limits as campaign accounts. This change only paved the way to where we are today with the proliferation of secret, unregulated slush funds that make it all too easy to abuse the power that inherently comes with holding public office. Stakeholders, lobbying firms, wealthy private actors, global corporations, and anyone who wished to do business with the state of Michigan or bend the ear of one of our most powerful lawmakers was encouraged to contribute to Lee Chatfield's dark money PACs that could be used in ways that served no benefit to our state residents, but allowed these wealthy donors to curry favor in ways unseen and unavailable to regular, average Michiganders who can't afford to fund an all-expense-paid trip to the tropics, but nonetheless who are desperate to have their elected officials care about their concerns and their struggles all the same. As I have said many times before, and will do so again today, the Michigan Campaign Finance Act is effectively toothless, useless, and utterly worthless as a deterrent to these crimes. The statutes governing political funds and donor disclosures in this state couldn't be more futile if they were literally drafted by crooks for the very purpose of violating them. The inherent weakness of these laws not only allows for pervasive, corrupt behavior, it encourages it and fosters it, and it spawns the perception that all elected officials are crooked since there's so little means to find out who is and who isn't gaming the system and subjecting themselves to what we can only call legalized bribery. Let me be clear. The misuse of social welfare funds is not a new practice in Lansing. And while Lee Chatfield may have exploited the system a little bit more than others, no one political party alone has perverted or abused it. This is simply the predictable product of the dark moneyed fueled culture we have here in Lansing. Corruption is predicated on greed, a fundamental disrespect for voters, comfort provided by weak laws, and the stone-cold assurance that no one will ever know, no one will ever be able to look, and no one can prove anything. So why not take advantage? And no one would have reviewed these accounts. No one would or could have seen the mountain of potential evidentiary material we had access to only by virtue of the allegations made by Rebecca Chatfield, which provided probable cause for our investigation. Politicians and donors count on it. They count on the fact that no one will ever see the inner workings because we simply don't require it, and that no one can prove the scheme or see the scandal. With this investigation and our major investigations, we're proving that to be wrong, but we can't change the culture on our own as an investigating and prosecuting agency. This prosecution required a unique and uncommon fact pattern, and it relied on uncommon allegations. To change Lansing's culture from one of secret donors and corruption requires and demands legislative solutions. These must come swiftly, and I'm very proud to be joining the Michigan House on Thursday along with Secretary of State Benson in support of the BRIGHT Act. As I've stated in previous press conferences, Michigan residents deserve more. They deserve better than what this flawed system has allowed. And with that, I'll open up the floor for a limited number of questions.
Excuse me. If you could raise your hands, I'll be calling on folks. I appreciate that very much. Excuse me. Tim, didn't we go over this? Like how we were?
I'm sorry, I was not here.
If you could raise your hand, we'll be calling on folks if anyone has a question. Thanks, Tim.
Thank you, Madam Attorney General. My apologies. Do you have an accurate number of the alleged dollars that were misused by Mr. Chatfield? And if convicted on all of these counts, how much time could he spend in prison?
Right. Well, first of all, conducting a criminal enterprise is the charge that carries the most time. It's a 20-year felony. That doesn't mean you get 20 years. It means that's the maximum amount of time. We haven't calculated the guidelines at this juncture. In terms of the amount of money we're talking about, obviously we haven't completed the investigation. I gave you some of the surrounding circumstances, but the exact amount of money that we believe was misappropriated involving just the Peninsula Fund or state money, we have various different charges. So I guess we have various different accounts, various different charges. So do you mean altogether between the Chatfield Majority Funds, the Peninsula Fund, and the state money, or could you be more specific?
Well, if I may have a follow-up, have you found any connection between the people that donated to Mr. Chatfield that resulted in his behavior as the Speaker of the House and legislator to do stuff for them?
Yeah. As I've indicated, our investigation is ongoing. And we have not completed the investigation, but we're moving forward with these charges now. So I don't have an answer to your question.
Great.
Two questions, if I can. One, there's a lot of evidence that other lawmakers were going on these same trips, some of these same trips that Lee Chatfield was going on. Have you found any evidence that other lawmakers benefited from this spending that's leading to criminal allegations against Lee Chatfield? And secondly, can you talk about where he is right now? Is he just going to turn himself in after attending a court hearing like others have, or has he been arrested?
So we've not charged any other legislators with any criminal conduct, and again, our investigation is ongoing. But we've not seen anything that would, at this point, lead us to believe there'll be charges against other legislators. In terms of where he is, yes, he will be permitted to turn himself in, and those arrangements, we've talked to his defense attorney, and we'll be coordinating that.
I was just curious, what was the guiding principle for deciding to charge Stephanie Chatfield on the first 4 counts, but not some of these other counts? I understand, obviously, you pointed out that she was overseeing money moved from the Peninsula Fund to pay off personal credit cards. Why just those 4 counts?
Those were the counts that we could prove her involvement in.
2 counts.
Yeah, 2 counts.
2 counts.
Yeah.
Although we're hearing about conduct today that you were able to announce with criminal charges attached to it, but do you believe or do you have any evidence that this type of behavior, this pattern of financial activity, happens with other policymakers in Lansing?
Well, I would say, of course, we did an investigation into Unlock Michigan, and we talked pretty extensively about, any improper uses in terms of that money. So I think we discussed that. Obviously, there were other charges that I can't speak specifically about, but will be heard in court involving the Menards that involved, of course, some of these same accounts. That's the important thing, right? We have very little in the way of mandatory disclosure in terms of how we know about what the exact use was of these funds. We also know that it doesn't take much to be able to utilize these funds, and that's why what we've charged here are, the counts where there's no feasible explanation for why that money would have been spent the way that it was. I should say feasible legal explanation. But that's the thing, right? Because there's so little information that is required. Again, we were able to conduct this investigation and sort of peek behind the curtain because of these, very serious allegations that were made by Lee Chatfield's sister-in-law. But generally speaking, like I said, this is an uncommon fact pattern. Will you normally have, the sister-in-law of a legislator make allegations of sexual assault and financial improprieties? I haven't seen that very often. It happened here. But again, you don't know unless you have a legal reason to look. And in this case, we did have a legal reason to look. But with most other elected officials, we don't. So we just don't know.
I'm going to go to Dave.
Yeah, Dave Yeager with Cranes. Follow up on Tim Studer's question. Is there a total amount of money you think was misappropriated, misspent, stolen across all the funds?
We have not completed the investigation, so I can't answer that question. There is still a lot more to go. But as I suggested before, I just didn't want to be in a position where these cases take so long. And I know I've been critical of the feds before for the enormous amount of time that it takes to charge their investigations. But, there's a reason for it. And just, again, all the things that we did in this case, when you're talking about subpoenaing a bank records, they have 90 days to respond to that subpoena. And then, it goes to, oftentimes some of these materials have to go to a taint team and get reviewed by defense counsel before it ever goes to the investigative team. And then once we've reviewed records, then, it leads us to need to subpoena other accounts. And that takes another 90 days. And then it just adds up over the course of a long period of time. So, again, I know it's not satisfying for us to make this announcement and to say this may not be everything, and we can't give you those totals. But again, for the reasons that I stated, I thought it was really important for us to sort of get the ball rolling for a number of reasons. One, so we could potentially reach some sort of conclusion on this matter, but also because I think it's important for the public to know, and this is a great example of where we've gone wrong, where we've lost our way in Lansing, and how we have an opportunity to do better than this. And I think the public deserves that.
Thank you. Ben?
Absolutely, Commerce Service. AG, just a quick question. I mean, we know about Rebecca's allegations, and we know that the case is closed now. But do you have any evidence, or are you investigating any other allegations of sexual assault against Lee Chapter from any other vendor?
All I can say is we have fully investigated that matter, and and the prosecutorial code of ethics, really, because we have a charged case here, it really precludes me from getting into details of any matters that we're not charging. But I will say this, I think that our department is a nationwide model for best practices when it comes to investigating sexual assault allegations. Daniel Hageman Clark, Daniel Bennett's, they're the best of the best. And we've taken on some very challenging sexual assault cases, cold cases from decades and decades ago, involving the clergy abuse investigation, where we charged 11 clergy members for cases that were very, very old. And so we really try to approach this from, a victim-centered, trauma-informed way. But we can't get into any more specifics because it just would be improper to do so, other than to tell you that we've closed out that investigation.
Go ahead, Paul.
Yeah, my question was along the same lines, just whether, given your record on sexual assault investigations, are you able to say, what the main obstacle was, if you can give anything further on why that investigation was closed without charging?
So if we just had the sexual assault investigation and we were not charging anything, I would be able to provide you at least some additional level of details. But because we have all of these other charges that are pending, it would not be fair to the defendant in this case for us to go into that in any degree of depth, other than tell you that we did an exhaustive evaluation, and we found that we could not prove criminal sexual assault charges beyond a reasonable doubt.
Yeah, Ben, back to you for the follow-up.
Absolutely, Congress follow-up. Are you disappointed that that's where the evidence landed? You being so similar to believing of sexual assault survivors making an allegation?
I don't go into any case having optimism or disappointment, about the conclusions of an investigation. We literally do our best to uncover the facts, and once we have all the facts that we can possibly find, we apply it to the law. And then once we've done that, we see whether or not bringing charges is appropriate. So this is not about being disappointed. It's not about having any degree of enthusiasm because there are charges. It's none of that. It's literally, I'm a prosecutor, and I'm here to apply the law to the facts. And if charges are merited, we proceed. And if they're not, if we can't prove the elements of any particular statutes beyond a reasonable doubt, then we don't charge. So that's the best I can say.
Alan?
Thomas,
Right. Well, my understanding is that Rebecca Chatfield initially made sexual assault allegations, but then shortly later she made additional allegations of financial improprieties. Is that a good explanation?
Yes.
Yeah.
John Hewitt, WWJ. I just wondered if you could characterize a bit in regard to the money that was allegedly stolen, in that were they for personal expenses, vacations, restaurants, exclusively, any examples of political influence being bought in the process? If you can characterize the motive for taking the money, if it was beyond personal use.
Yeah, I can't speak to anything else except for what we've specifically charged, understanding that the investigation is ongoing, but I will tell you that many of the charges involve monies that were clearly converted for personal use that was not appropriate for a, social welfare nonprofit.
Lisa with MERS News. I apologize, my throat's sore. Have you closed your C4, and if you have or have not, why?
I have.
Simon?
Who are the primary donors to the Peninsula Fund? Who enabled this kind of fund?
Right. Well, I think some of that is a matter of public record from the 990s. I think I've read about that in Craig Mager stories in the past. So, I think... Right. Okay. That's going to come out during the course of the investigation.
Just to follow
I mean, in the course, I'm sorry, pardon me, in the course of the case as it's presented.
Craig from the district. Can you just say yes or no to whether any donors to the Peninsula Fund are under investigation by your office right now?
Yeah. So I'm going to say this, and let me answer a few questions this way. Firstly, that our investigation remains ongoing, and so I can't disclose any of that. But let's talk about for a second in terms of like buying influence. Like, what does that mean, right? And I think there are different ways to buy influence, and unfortunately, some of those have been kind of legally codified into the law here. So, when you are giving massive amounts of money to a 501c4, and especially when that money is then utilized for what appears to be personal reasons that are not related to the mission of that nonprofit, I would characterize that as buying influence, and I would characterize it as buying influence in a way that, again, regular people can't do in order to have, their concerns met or their voices heard. So, I think we've come to think of for instance, bribery as this quid pro quo, like I am giving you money for you to pass this bill or for you to introduce a bill. And then there's some communication saying like, here is the money for whatever, Senate Bill 401B, and that is a way to look at some types of corruption, but other types of corruption, like I said, may not be illegal. Something can be corrupt and be legal at the same time. And I think that generally speaking, that's what we see with a lot of these accounts, that they're utilized that way, right? In a way that creates the specter of corruption and a corrosiveness to public discord. But at the same time, it's not prohibited under the law. And that's why we're really hopeful that there will be some changes to this. But at this time, again, I'm not going to answer any further questions in regard to, who else we might be investigating.
Joe, you have expressed that you want lawmakers to expand financial disclosure laws, transparency, but you yourself have not provided voluntarily financial information, such as the value of your home, things like that. Can you explain, why you want those laws to be expanded, but you yourself haven't provided that information?
So you think that people should just have to, individuals that you put pressure on should provide voluntarily, how does the value of my home in some way curry influence with any of the decisions that I make? How much money I have in my 401k, how much money I've saved over 30 years of being a lawyer, in what way, shape, or form, I guess I would ask, does that influence the work that I'm doing? I would suggest to you that it does not, but if the legislature wanted to pass a law and say you have to provide this information, absolutely I will. You might have noticed, I didn't see this reported on in the Bridge Magazine article, but I had 0 drinks paid for me by lobbyists during this reporting period. I had zero meals paid for me, 0 travel, 0 tickets, none of those things. I know that good governance doesn't sell papers. But, I have tried to hold myself to the highest of standards. But what I am saying is this. I am encouraging, endorsing, basically pleading with the legislature to have laws that allow for greater transparency, not for one person in elected office, but for everyone in elected office. And that's the way to be fair and just, but also to be transparent.
Yeah, Lisa?
Oh, I apologize. Lisa with MERS. I didn't hear you say why you closed your C4.
I didn't feel as though I needed a C4.
Okay.
Jordan Hermany with Bridge.
Apologies. Backing into this, I understand that you've said the investigation is ongoing. Do you, though, of the charges announced today, have a tally of how much between all the separate funds that Lee Chatfield stands accused of embezzling? Do you have a dollar amount?
Do you mean a dollar amount for the monies that we've charged just based on these particular acts that we have charged?
Understanding that this is an ongoing investigation.
Right. Do we have that? I don't. Okay. We don't have that, but, again, there will be affidavits that will be available at a later juncture that should spell a lot of that out.
Time for two more. Simon?
Attorney General, Democrats have had control of the legislature and the governor's trifecta control of government for more than a year now. They called repeatedly for investigation into Lee Chatfield's conduct while they were in the minority in the legislature. What do you think it's going to say to you if the legislature doesn't act and make steps to address this kind of conduct through policy?
It's not what it says to me. It's what they'll be saying to the public at large. It's what they'll be saying to the over 10 million residents of the state of Michigan. And I think the message would be that transparency is not very important to us.
No last question. Al?
Well, I'm just going to say this, not knowing more than what I've read about it, which is very brief, is that the allegations seem to be that the crimes were bias-related, bias-motivated, and based on the sexual orientation of the victims. It's not an included class under the Ethnic Intimidation Act. It would be under the proposed laws in both the House and Senate that would amend or at least create something called the hate crimes laws as opposed to ethnic intimidation. I have encouraged the legislature to move forward on that, and this might be an example of why it's so important that they do so.
Thanks, everybody.
Thank you.